Members, it's the appointed time and we have a quorum. Let's start the meeting. This is our 9th meeting. We will continue to scrutinize the bill. We've finished scrutinizing page 141 of the marked up copy, that is the Chinese version. So the government, please start with page 142 of the Chinese version of the marked up copy. Please, legal advisor, remind members on the points about law drafting, if necessary, and when we are scrutinizing the Chinese version of the bill, please, with the legal advisor, check if the English version is proper. Thank you. Mr. Chang, please continue. Please refer to page 126 of the English version. Section 24, penalty for fraudulent registration. We have not amended the provisions, but according to the letter of Dr. David Lam, he asked what is the difference between fraudulent registration and other offenses. Under Section 24, any person fraudulent procures or attempts to procure himself or any other person to be registered under this ordinance, or his or any other person's name to be included in the specialist register, they will be subject to a penalty of imprisonment of 3 years. This here, a representation of the will have to be made to the dental council. If the person does not provide a dentistry service and make such a representation, they will be subject to a penalty under Section 24. But as for Section 3, bracket 1, or Section 3, it stipulates that a person who fraudulently procures himself to be registered shall not deemed not to be so registered. We can see that these are two very different offenses. Dr. Lam asked about Section 3, bracket 3, which stipulates that a person who fraudulently procures himself to be registered shall be deemed not to be so registered. How should it be read? According to Section 24, person A fraudulently procures or attempts to procure registration from the dental council and practice dentistry. According to Section 3, bracket 3, they cannot provide a defense by saying that they have been registered under the dental council to circumvent the criminal liability. That is not possible. Now we've come to Clause 134, Part 16. Section 25 provides for the penalty for falsely pretending to be or taking or using the name or title of a dentist. A person may print the word dentist as their job title on a name card, and if they do so, they will violate Section 25. Section 3, for a person to violate such section, they will have to provide a dentistry service or dental service, and that is why we have to distinguish between the two, because a person may provide dental service without claiming to be a dentist. Under such circumstances, we have to invoke Section 3. Unless otherwise specified, a person cannot proclaim to be a dentist. Because in the future, we will be having dental care professionals, and that is why we will stipulate the penalty for relevant offenses for dental care professionals. A1, dental or dentist, or persons deemed to be dentist or dentist with professional, dentist can claim to be a dentist. So interns can claim to be a dentist, and the patients can, when patient asks, the dentist can say that they are a dentist, or the interns can say that they are a dentist.
故意虛假地充
Now on B, that is if a person is qualified to practice dentistry. That is someone who takes or uses any name, title, addition, or description, implying whether in itself or in the circumstances in which it is used that one is a dentist or is qualified to practice dentistry. We did not know where the existing B came from, which is why we amended B to reflect our current policy intent. Also, we have added 1A. An enrolled dental hygienist does not commit an offense if he or she takes or uses any name, title, addition, or description, implying that he or she is qualified to undertake the kinds of dental work prescribed in the relevant regulations. Similarly, with dental care professionals, we have similar profession. Also, for subsection 2, we have retained the current offense and the penalties. Thank you. Dr. David Lam, I understand the reply given by the administration. I now have a further question. So, the title for dentists, the meaning, I did some research. It actually meant someone who did not graduate from a dentistry program but practices dentistry. A dental doctor would have to be someone who has officially graduated from dentistry programs. I believe there is no distinction at the moment in that regard. Well, let me say this. Dental officers are still called dental officers in the Department of Health. This is why we still would allow someone who would say that they are a dental officer. Thank you, Mr. Denslung. It is said that for this section, it would be a summary conviction to a fine at level 6 and to imprisonment for 3 years. And for section 24, the penalties are different. Also, section 25 specifically would have a fine. For section 24, there won't be any fines. It would only be the case that liable on conviction upon indictment to imprisonment for 3 years. Why is there such a great difference in the penalties? Thank you. In fact, this question was asked when the ordinance was last amended in 2005 and 2006. Where did this imprisonment penalty in section 24 come from? It is because referring to similar legislation, that is the one for medical practitioners. If one does something similar, one would be liable to an imprisonment term for 3 years. As for section 25, we consider the offense to be serious because one may be misleading a member of the public that they are a dentist, and there may be perks stem from it. That's why we would have a fine for this, and then we would also impose an imprisonment term for 3 years should one commit an offense in this regard. Thank you. Ms. Lillian Kwok, I want to ask more about the summary conviction clause. In general, it would be the case that an imprisonment term would be 6 months or 12 months. Is it the case that if it is on summary conviction for the relevant section, it would automatically be 6 to 12 months? I'll let the DOJ colleague answer this. Thank you. I think you are referring to when to initiate proceedings. It is not specified in the sections. We would have to refer to the magistrate's ordinance. I think a reply can be provided on the next occasion. Thank you. Mr. Lam Chen Sing. Regarding imposing as a dentist, if one is a dental hygienist, they can only claim that they are dental hygienists and perform the relevant work. And similarly, dental therapists would be that. But some may be capable of doing both. But that person is only qualified to be a dental hygienist. So when some procedures are being performed, if there is a problem, the dental hygienist may have to perform some work that can only be done by a dental therapist to remediate the situation. If one can only act as a dental hygienist, they will just have to leave it be. So there's the dilemma. If they do something, if they are qualified to do, if they're not qualified to do so, they will be punished. But then if they don't do anything, that may also be a negligence of their duties. Thank you. Well, as the members said, we will talk about that in later provisions, but in general, for Section 15B, if it is a dental care professional, and for example, if one is a dental hygienist or a dental therapist, they can claim themselves to be dental care professionals with the actual work. This would relate more to what is happening in an inquiry. They will not be subject to imprisonment, but they would have some explaining to do during an inquiry. Ms. Judy Chen, I want to follow up on what Dr. Lam asked earlier. I think we as laymen want to know more the distinction between dentists and dental officers. If this distinction is outdated, should we amend this while we're scrutinizing this bill? Mr. Ching, thank you. I think everyone understands what a dentist means. Dental officers in general are only used in the Department of Health to refer to a position. We want to include dental officers as well because we don't want people exploiting this loophole saying that they are a dental officer, which is why we have included the term dental officer to make sure no one could exploit this loophole. Does that answer your question? Thank you. Dr. David Lam. Excuse me. For a DCP, for a single class, they can only register for one. They can't register both as a dental hygienist and a dental therapist. So they can register for both, it's just that the certificate would only say one of them. That is, the practicing certificate can only put one of them in there. Okay? So if indeed what Mr. Lam Chen Sing said happened, I believe dental therapists can do more than dental hygienists. Say if a dental hygienist or has the title of a dental hygienist if the situation warrants that they need to do more. And there is the case that the title that says otherwise, would it suggest that they may be doing more than they're qualified to do? And you're saying people should refer not just to the title but to the practicing certificate and this register. Indeed, as said in section 25, if one is enrolled as a dental hygienist or registered as a dental care professional, we do not have much requirement as to the name. We just ask that they are qualified to undertake the kinds of dental work that they are supposed to do or provide the services specified. Thank you. I believe there are no questions. Please proceed. Now we are on section 25A, penalty for falsely pretending to be or taking or using the name or title of a specialist. We have not made any changes. We have only added section 25B after this, penalty for falsely pretending to be or taking or using name or title of dental care professional. Subsection 1 subject to subsection 2, a person commits an offense if A, the person is not a registered dental care professional and the person willfully or falsely pretends to be one, or takes or uses the name or title of one, or imply themselves to be one. Subsection 2, a registered dentist, a person deemed to be a registered dentist, or a person with provisional registration does not commit an offense. Of course, dentists should not be regarded as committing offense because they are qualified to do such work. Subsection 3, the penalties. Thank you. Please proceed. Section 26. Section 26 will be repealed. There is some history behind this. Section 26 refers to an ordinance that has been repealed. It was an ordinance in 1940. Before, it was quite lax, and if one has the approval of 2 justices of the peace, one would be able to practice dentistry. But they cannot say themselves to be a qualified dentist. We have much advance in dentistry, so we consider someone who has not taken any qualifications in dentistry to be somewhat hazardous if they practice dentistry. That's why we have repealed this section altogether. Section 27. Also, let me talk about the background. In 1959, it was made an offense if a dentist practices dentistry in premises in which an unregistered person practices dentistry, commits an offense, and is liable on summary conviction to a fine at level 3 and to imprisonment for 6 months. So say in a premises there is one registered dentist and then there is one unregistered person practicing dentistry. The registered dentist will commit an offense, and this is a strict liability offense. This may seem unfair because this has some history, because before it was considered that there may be a conspiracy involved, that the registered dentists would often know that other unregistered person practicing dentistry. But right now we have often seen partnerships, and essentially one would be required to monitor another's conduct, and we think this is unfair. In fact, when this was promulgated in 1950s, this was debated in High Court because there was a dispute, because we have seen such operational difficulties. We have proposed a new Section 27. We would consider that only those who knowingly allows another person to practice dentistry used by or under the control of themselves would commit an offense. Let's look at this in detail. Subsection 1. A registrant who allows another person who is not a registrant to practice dentistry on any premises used by or under the control of the registrant commits an offense. So allow would mean that the registrant would know about this. So we believe that would reflect that knowledge is important in determining whether someone has committed an offense. Subsection 2. A registrant who, by his or her presence, countenance, advice, assistance, or cooperation knowingly enables a person who is not registrant to practice dentistry commits an offense. So again, the important word is knowingly. If one is in another room practicing dentistry and you don't know about this, you would not commit an offense. Subsection 3. If a registrant knows or has reason to believe that another person is not a registrant but practices dentistry on any premises, and the registrant practices dentistry on the premises, the registrant commits an offense. So this would essentially have a higher threshold than the other subsections. In subsection 4, the penalties. We have referred to the penalties on the practice of overseas jurisdictions. We believe through such references there would be clear delineation of responsibilities. Subsection 5. If a person is charged with an offense under subsection 1 or 2, it is a defense to establish that a. the commission of the offense was due to a mistake on the person's part, or due to reliance of information supplied to the person, or due to the act of another person, or any cause beyond the person's control. Well, why is subsection 3 not included? This is because we would say that one knows, and that's why we said subsection 3 would have a higher threshold. That's why a defense is not available to make up for that. Let's now go to subsection 6. This is again a standard provision of the DOJ regarding how to establish a defense, the threshold for it specifically. Subsection 7. For the purposes of this ordinance, a person is to be regarded as not being a registrant if a person is a registered dental care professional or practices dentistry by providing a service that is not one specified in column 3 of that part opposite the class. That is, if one is doing such, one should not be regarded as a registrant that is a dental care professional and whatnot. Thank you. So, Dr. David Lam, I want to ask, if an unregistered person is practicing dentistry on the premises and the dentist knowingly allows that, we would have some penalties. Operationally, it may be difficult to prove. For example, one has signed a contract and one must work in the premises. And once they start working in the premises, they found out that, for example, a dentist there is not registered. If one has to resign, they may have to pay a substantial amount of money back to the office. Is it possible that you can allow an avenue for them to report this or to distance themselves from the company, and it would be a defense? Thank you, Mr. Ching. I think Dr. Lam has given a very good feedback here. We will definitely consider this to see how we can better draft the session. Thank you.
No further questions. Let's continue. Let's move on to the next part, Part 17, Miscellaneous. 27A. Restoration of persons whose names have been removed from registers. Subsection 1. This section applies if A. The name of a person was removed from a part of the General Register or Register of Dental Care Professionals. Either 1. The name was so removed on an order made under Section 18 or 18A with the right to apply for restoration under this section after the expiry of a period, or 2. The name was removed on an order made under Section 15(3) or 15K(4). In subsection 2, the person may apply to the Council for the restoration of the person's name to the original part. During the application, in the case of a disciplinary hearing, one needs to make the application during the suspension period. Now we amend the period to 3 years. In B, be made in the specified form, and C, if the original part is Part 1 of the General Register, indicate the applicant's wish, if the application is approved, to have the applicant's name contained in the practicing list or the non-practicing list. Let's continue with brackets 4. The Council may, after any inquiry and subject to any condition that it considers appropriate, approve or reject the application. 5. The Council must notify the registrar of the decision or the reason for rejection. 6. On receiving a notification under subsection 5, the registrar must: A. If the application is approved, notify the applicant in writing of the Council's decision, and 2. After the prescribed fee has been paid, restore the applicant's name to the original part. Or B. If the application is rejected, notify the applicant in writing of the Council's decision and reason for it. In subsection 7, if before the name was removed, the person was a person with limited registration or with special registration, the registration of the person affected by the restoration of the person's name under this section is to be enforced until the earliest of the following. For limited registration and special registration, the period is for 3 years. If we restore the name of the person to the register, we need to know the mechanism. In A, the expiry of the period specified under the section in respect of the limited registration or special registration. In brackets B, the termination of the person's employment mentioned in section 9D brackets 2A or 19 brackets 2A. Subsection C, the removal of the person's name from Part 3 or Part 5 of the General Register under an order made under Section 15, 18, or 18A. In subsection 8, if the original part is Part 1 of the General Register, the registrar must enter the applicant's name in the practicing list or the non-practicing list according to the wish indicated under subsection 3C. Dr. David Lam. Thank you, Chairman. In 7C, I understand if a person under Section 15, 18, or 18A needs to have his or her name removed, one needs to cease limited registration or special registration. Why do you have to mention this once again? Actually, not just for dentists under limited registration or special registration. Is that redundant? But it doesn't matter. Even if you are not going to write it down, there will also be the same effect. I'd like to ask about 27A subsection 1, or the entire section 27A is about the restoration of persons whose names have been removed from registers. But you didn't mention how a specialist can have his or her name restored to the specialist register. There is no mention of the specialist register. Mr. Ronald Chang. Thank you, member. Regarding subsection 7, in the event of a disciplinary hearing, that person's registration should not be deemed valid. The reason why we have a general register and a register of DNCP, but then we do not have a specialist register, because we need a more detailed procedure. we need to go to the relevant committee. That is the Examination, Education and Accreditation Committee. So it is not up to the registrar. We need to go back to the Education and Accreditation Committee before we can make these decisions. We'll take a look at it. We'll consider how we can put in place, how to specify the mechanism more clearly. But there is an appropriate mechanism to work around. On page 137, Section 27B, Council may issue Code of Practice. There's a Code of Practice issued to dentists on General Register and Specialist Register. We made it clear how to handle the Code of Practice. In subsection 1, the Council may issue a Code of Practice for the following purposes. A. Setting the standards of conduct and practice for registrants in relation to the practice of dentistry. Subsection B. Providing guidelines regarding the activities of registrants in relation to the practice of dentistry. Subsection 2. The Council may issue different codes of practice for different classes of registrants, and B. may issue different codes of practice for different purposes. Subsection 3. The Council may from time to time revise or revoke the whole or any part of a Code of Practice. Subsection 4. The Secretary must, as soon as practicable after the registration of a person, cause a copy of a Code of Practice that applies to the person to be sent to the person. In subsection 5, if any part of a Code of Practice that applies to a person is revised under subsection 3, the Secretary must, as soon as practicable after the revision, cause a copy of the revised part of the Code of Practice to be sent to the person. If the Code of Practice for physiotherapists is amended, then the Allied Healthcare Professionals Associations needs to work accordingly. Subsection 6. If a Code of Practice issued or revised under this section is inconsistent with this ordinance or regulations made under Section 29, the latter provision prevails over the former provision. So the Code of Practice will not prevail over the regulation of the Dental Council of Hong Kong. Mr. Dennis Leung, thank you, Chairman. In 2B, may issue different codes of practice for different purposes. How many different purposes do you speculate there will be, or do you expect there will be in the future? So they will be handled by way of the codes of practice. There is a purple booklet that is the Code of Practice for dentists. In 2019, on online social media, there were different events leading to the revision of the Code of Practice. In the future, we expect that there will be such a purpose or such a need for DENCPs as well, hence this provision. On page 138, Section 27C, Registrar may request provision of means of contact. The Registrar may request a person to provide to the Registrar a means of contact other than an address for the purposes of Section 27D, brackets 2C. We have decided to add this provision is that under the Dentist's Registration Ordinance, we need the telegraph service to provide an address, but after several decades, if an address is not appropriate, Then we also allow other means of contact for the relevant means of contact to be provided. Section 27D, means of service. This section covers many different means of service. In subsection A, a notice required to be given to a person under different sections. B, a copy of an order. Bracket C, a copy of a code of practice or the revised part of a code of practice, or subsection D, a summons mentioned in section 19, bracket 2. In subsection D, we specified different means of service. In brackets A, it is delivered personally. In brackets B, it is sent by post if the person is a registrant to the last registered address provided by the person to the registrar, or brackets 2 if the person is not a registrant to the person's address last known to the registrar, or subsection C, bracket C, it is sent by using a means of contact provided under section 27C. Subsection C, the document is, in the absence of evidence to the contrary, to be regarded as having been given or sent to or served on a person. Actually, the time of the issuance of a document is crucial. Brackets A, if it is delivered personally on the date on which it is delivered. Brackets B, if it is sent by post on the day after the date on which it is sent, or brackets C, if it is sent by using a means of contact provided under section 27C on the date on which it is sent. No questions, let's continue. Section 28, for feature. If a person is convicted of an offense against section 3, brackets 1, a magistrate may, on application made on behalf of the government, order that all dental materials and equipment in the possession or under the control of such person shall be forfeited to the government. We have added, or brackets 1b, this is a technical amendment. We have not made any amendment in relation to the power. Section 29, about regulations. Under the dentist's registration ordinance, different persons can make different regulations. In section 1, there is no amendment. The chief executive and council may by regulation provide for any fee required to be paid and the disposal of any fee paid. Upon the passage of the dentist's registration amendment bill, we will make another regulation on fees. In subsection 1a, the Secretary for Health may by regulation provide for brackets A, we will change the duties to functions. We have already provided for the definition of function in the interpretation section of the bill. In brackets B, the duties of the legal advisor. We agreed with the Legal Services Division of the Council, so we won't move an amendment right here. So section B, the duties will remain. In bracket C, the duties of the secretary. When there is a registration system for DEN-CPs, the secretary can make amendments in relation to Schedule 3. So the Secretary for Health can amend Schedule 3 and that will suffice. We will explain further in subsequent provisions. In brackets 1ab, the Permanent Secretary for Health may by regulation provide for the procedure and other matters relating to an election for appointment to the Council under Section 4, including the qualifications of candidates, the eligibility requirements for electors and subscribers for a nomination form, the particulars of any system of voting and counting, the determination of election results and questioning of the results. The Permanent Secretary for Health can provide for these regulations. We will make further regulations in relation to dentists and lay persons. This is quite a long section. Any question from members? No, let's move on. Subsection 1b. the registrar may by regulation provide for the following. We will delete the form of the general register. We think the form of the general register is redundant, so we will delete it. For B, we will make the amendments in Chinese from 委員會, that is committee, to 牙管會, that is Dental Council of Hong Kong. In subsection 1C, subject to the approval of the Secretary for Health, the Council may by regulation provide for A, the procedure to be followed at meetings of the Council, B, the receipt of complaints or information about any a committee established under Section 5AC or a subcommittee established under Section 5AD, and the procedure to be followed by the members of the Council, committee, or subcommittee. In the past, the procedures of the Dental Council of Hong Kong, as we can see on the right, we will add the following. That is a committee established under Section 5AC or a subcommittee established under Section 5AD, and the procedure to be followed by the members of the Council, committee, or subcommittee. In brackets B, we consider the Health Committee, that is may not just preliminary investigation committee. BA, the ascertainment by the chairperson of a preliminary investigation committee as to whether a complaint or information about any registered dentist. If a person is involved in the preliminary investigation committee when the case goes back to the Dental Council of Hong Kong, which is a higher level, that person should not appear again. Otherwise, that will render the procedure not fair to dentists or DenCP. So we will provide for regulation which can better regulate the situation. In brackets D, the procedure to be followed in relation to 1. The submission of complaints or information to a preliminary investigation committee. In DA, it's about the procedure and the eligibility. DB is a new part. There are codes of practice for the Dental Council of Hong Kong, but we also allowed it to make some regulations. They will allow regulations to be made by the supplementary medical, in accordance with the supplementary medical professions ordinance. Any questions? No. Let's go on. In brackets E, there is no change. It only specifies a form or any other document. In 1D, we have added brackets 1AB, so we added brackets 1AB to subsection 1D. 委員會 will be changed to 牙管會, that is from Committee to Dental Council of Hong Kong. And in brackets AB, we have added provide for any incidental, supplemental, evidential, consequential, savings, or transitional provisions that are necessary and expedient in consequence of the regulations. So in order to avoid any possible further amendments in the future, we make it clear that the Dental Council of Hong Kong can make the relevant transitional provisions in the future. In brackets B, there is no change at all. In subsection 2, any regulations made under subsection brackets 1A may prescribe different fees to be payable by different categories of persons. No questions. Let's continue.
四頁咧，我哋係
Page 146. That's about the power of council to specify forms. The Chinese translation of the council will be changed from 委員會 committee to 牙管會 DC Council or Dental Council. you can see that under bracket 8 is amended as the form and manner of making an application under this ordinance, and the form of a certificate or any other document required or authorized to be issued under this ordinance, so that dental council can specify forms for their members to follow. Bracket 2, the Chinese translation of the council will be changed from 委員會 to 委員會 dental council. Under subsection A, as we will be having dental care professionals in the future, we change the registered dentist to a person. B, as to whether the particulars contained in the form are true and correct to the best of the dentist, now we change the word from dentist to a person's knowledge and belief. Bracket 3, a form specified under subsection bracket 1 bracket A shall be completed in accordance with such directions and instructions as specified in the form and accompanied by such statements, certificates, or any other documents. We have not changed this provision. Section 29B is a new section. We have made reference to the Nurses Registration Amendment Bill. That is, the Secretary for Health may, if the Secretary for Health considers it is in the public interest, give written directions of a general or specific character to the council in relation to the performance of its function, and that is in line with the Nurses Registration Amendment Bill. Section 29C, that involve a series of schedules and who may specify the details of the schedule. When we come to the schedule, members would know more about that. Now we've come to let's talk about bracket 1. The council may, subject to the approval of the Legislative Council, amend Schedule 1 by notice published in the Gazette. Members may refer to Schedule 1 that refers to the specified institutions under which the graduates don't have to go through the licensing examinations in order to become a professional dentist. That is the University of Hong Kong. Bracket 2, subject to the approval of Secretary for Health, the Council may, by notice published in the Gazette, amend Schedule 2. Schedule 2 is about services specified for meaning of practicing dentistry. And what kind of work can only be undertaken by the dentist? That's set out in Schedule 2. If Dental Council want to amend the Schedule 2, they can do that by notice published in the Gazette. So we empower the council to propose such an amendment, and with the approval of the Secretary for Health, we can amend Schedule 2 to amend the meaning of practicing dentistry so that it can be kept up to date. The Secretary for Health may, by notice published in the Gazette, amend Schedules 3, 4, 5, 6, 7, 8, 10, or 11. What are these schedules? Schedule 3 is matters relating to dental care professionals. As mentioned previously, the power lies with the Secretary for Health, and now Dental Council can propose amendment. Schedule 4, limited registration. Schedule 5, special registration. Schedule 6, internship. And these schedules are about their institutions. Schedule 8 is about internship and period of assessment and the length of the internship and period of assessment. They are 12 months, and that's set by the Secretary for Health. As for Schedule 10 and Schedule 11, they're about corresponding amendments. These are some very technical kind of details. Bracket 4, the Council may, by notice published in the Gazette, amend Schedule 9. Schedule 9 are transitional provisions. It's about the transitional arrangement before the passage of the bill or the implementation of some regulations. For Schedule 10, it's about the procedures that dentists have to go through to migrate to full registration. No questions? Please proceed. Section 30, assumptions. Previously, there were people who are not subject to Section 9, 10, and 14 requirements. As we have amended the ordinance, or we will amend the ordinance, we want to clarify the requirements relating to provision of address and registration. Let's talk about bracket 1. all registrants in the public service of Hong Kong shall, while in the discharge of their duties or while practicing dentistry otherwise than for gain in a charitable clinic approved by the Council, be exempted from Section 12G and 15I. By amending this provision, we can clarify the requirements on registrants performing public service. Bracket 2. Dentists of the Chinese People Liberation Army residing in Hong Kong will be deemed dentists, and we will be keeping the provision. While they are discharging their duties or while practicing dentistry otherwise than for gain in a charitable clinic approved by the Council, they will be deemed to be registered dentists for the purpose of Section 3. And these provisions will not apply to such dentists unless they practice dentistry privately in Hong Kong. Bracket 3. All persons on the full-time teaching staff of the Faculty of Dentistry of the University of Hong Kong should register with the Dental Council. Previously, these teaching staff of Hong Kong U will be automatically deemed as dentists, and now we will amending the provisions to ask the teaching staff to be registered as a dentist in Hong Kong. For Section 14, it will be repealed. That's about registration certificate. After the teaching staff have been registered with the Dental Council as dentists, we will be repealing the relevant section. Bracket 4. All registrants in the full-time service of the Hospital Authority are exempted from Sections 12G and 15I. So what is 12G and 15I? That's about provision of address. In the future, the public officers will only have to declare that they work for the government, the Hospital Authority, and the Department of Health before they can practice in Hong Kong. We will be repealing the deemed to be registered status. That is why we will be repealing the subsection 3. Section 31, exemptions. Bracket 1, nothing in this ordinance shall operate to prevent the practice of medicine or surgery by medical practitioners registered under the Medical Registration Ordinance. Because the DRO will not cause any medical doctors to be held criminally liable. Bracket 2, nothing in this ordinance shall operate to prevent the training of medical students, dental students. We used to also specify dental therapists and dental hygienists in the practice of dentistry under the supervision of registered dentist or person deemed to be registered dentist during a course. As we will be having some dental care professionals in the future, that is why we will be substituting dental therapists and dental hygienists with dental care professionals. Bracket 3, nothing in this ordinance shall operate to prevent the performance by dental therapists employed in the public service of minor dental work of such a character as may be authorized in writing by a government consultant dental surgeon appointed by the Director of Health for that purpose. As dental care professionals will cover dental therapists, that is why we will be substituting dental therapist with dental care professionals. We used the word minor. Well, the translation of the word minor used to be 輕微, and now we will be amending that. We changed the Chinese translation to 簡單, simple, instead of 輕微, mild. That is the Chinese translation of the word minor. Bracket 4, this ordinance shall not prevent the operation of an irradiating apparatus by a person authorized to operate the apparatus under Regulation 26 of the Radiation Control of Irradiating Apparatus Regulation. So a person operating relevant apparatus will not be affected. No questions, please proceed. Now we've come to Section 32, transitional. In 2005 and 2006, because we wanted to establish a specialist register, we have established these transitional provisions that specify how a person can be registered in the specialist register with conditions. We keep that here because 2005 and 6 are not that long ago. Some people may still be adopting such practice. Again, we will change the Chinese translation of council. Section 33, that's the transitional provisions. We want to make sure that the provisions will have legal effect. That are those in Schedule 11. Section 34, I may have to elaborate on that. That's about regulations for consequential amendments consequent on enactment of Dentist Registration Amendment Ordinance 2024. The provisions and parts of the ordinance may be implemented in phases. Say the registration scheme of the dental care professionals will only be implemented 3 years after passage of the bill. Before that, we don't have this concept of dental care professionals in the law. And after passage of the bill, we have to make relevant amendments to the ordinance. That is why in Section 34, like companies ordinance, we want to empower a public officer to make relevant consequential or related amendments so that the provisions will be complementary. So in bracket 1, the Secretary for Health may by regulation make consequential related amendments to any enactment as are necessary consequent on the enactment of the amendment ordinance. Bracket 3, regulations made under subsection 1 may provide for any provision of the regulations to take effect on a date earlier than the date of publication of the regulations, but not earlier than the date on which Section 79 of the amendment ordinance comes into operation. Bracket 4, to the extent to which a provision of regulations made under subsection 1 takes effect on a date earlier than the publication date, the provision does not operate so as to affect in a way prejudicial to any person or to impose liabilities on a person. Amendment ordinance in this section means the Dentist Registration Amendment Ordinance 2024. No question, please proceed. Page 152. We've come to Schedule 1. We specify the definition of qualifying degree in dentistry. Graduates from qualifying degree don't have to go through licensing examination, and they have to go through an internship. It used to fall under Section 8, and the universities in Hong Kong specified for the relevant purpose is the University of Hong Kong. Schedule 2, services specified for meaning of practicing dentistry. Under Section 2A and 29C, the Secretary for Health can amend the meaning of practicing dentistry. Previously, it was limited to dentures. As the practice of dentistry has changed with times, we specify the services. First, examine the condition of the mouth of another person. If a person is just examining their own condition of their mouth, that's not practice of dentistry. The person have to examine the condition of the mouth, teeth, jaws of another person or their associated structure to facilitate the diagnosis or treatment of any disease, pain, disorder, deficiency, deformity, so on and so forth, without limiting the provision above the taking of a digital impression with an intraoral scanner. So taking of a digital impression with an intraoral scanner fall under definition bracket 1. 2, diagnose or treat any disease, pain, disorder, deficiency, and so on and so forth of another person or the associated structure. 3, perform any procedure or operation on another person. 4, prescribe, apply, or insert any substance, artificial tooth filling, device, appliance, or prostheses for the alteration, restoration, regulation, or improvement of the mouth, teeth, or jaws of another person, or their associated structures, including without limiting the provision above. A, the carrying out of the dental bleaching or teeth whitening procedure. B, the prescription of clear aligner. And C, the carrying out of teeth veneering procedure. We think that teeth veneering and dental bleaching should only be done by dentists. The sector has been asking for such requirements and regulations, and that is why we are implementing the suggestions from the sector. Page 154, that's Schedule 3, matters relating to dental care professionals. We talk about different classes. Under column 1, we have dental hygienist and dental therapist. They serve the patients directly. That is why they fall under column 1. If we have dental technicians in the future, they may fall under column 2. Column 3 is about the service they can provide, and column 4 is about the conditions under which they have to they provide service. For column 3, we can see the cleaning and polishing of those parts of the surface of the teeth. For cleaning, we're talking about polishing. That will not involve bleeding. That is why we don't require the presence of a dentist. B, the application to the teeth of another person of any topical fluoride, fissure, sealant, or other similar preventive agent. When there is cavity on any tooth, the dental hygienist can fill the part, and these are not invasive. C, the taking of a radiograph intraorally or extraorally for the examination of the mouth, teeth, or jaws of another person or their associated structures. We impose condition 1, that is the dentist will have to look at the medical history of the patients before such procedures can be done. D, scaling. We'll set out the definition of the scaling. That's set out under Cap 156. That is cleaning the stains and calculus deposits on the surface of the teeth, and that also include application of medicaments. The conditions set out in sections 1 and 2 of Part 2 of this schedule must be met. Ms. Chen Hao-yan. We didn't have conditions previously. The cleaning and polishing of those parts of the surface of the teeth of another person that are not covered by gum. And the conditions could be in the presence or under the supervision of the dentist. Do we impose conditions on the place where the service is performed? You are very detailed in terms of column 3, service. You specify the part that is not covered by the gum, and when there's likelihood of bleeding, then you will specify that the dentist must be present. Can a dental hygienist perform service under column 3 in their homes? Do we have any conditions on the premises in which the service is performed? Mr. Cheng. Let's look at the current practice first. In terms of premises, are you talking about page 178? Where are you referring to the blue bill? We're referring to the marked up copy. Conditions. Before the service is provided by the registered dental care professional concerned to another person, a registered dentist or a person with professional registration has assessed the medical history and has based on the assessment or examination be provided to the patient. So the dentist must be present when the service is performed. Can the service be performed at a residence? As mentioned in other parts of the ordinance, the service must be provided for in an appropriate or proper place. And if they carry out such service in a place that is not proper, they will be subject to disciplinary action. Because in the conditions you set nil, for conditions, we only specify if the presence and supervisions of the dentist should be there. For premises, there is no that fall under other provisions.
嗰個條件
Well, I am asking this because you are saying in the conditions, for example, one should be subject to the supervision of a dentist, which is why I'm asking why this premise requirement is not included as a condition. Of course, a dental hygienist has to perform their duties in a suitable premises, and that is a requirement or a condition. Why is this not included then in column 4? So if you only say conditions nil, people would think that they are not subject to requirements. They may just bring their tools to a certain person's home and perform the relevant services. I'm confused because you just say there is no condition here. If there is such condition regarding premises, you should set out here the reference, just like what you did for C and D, Mr. Ching. We can perhaps refer to page 123. It will be clear of the Chinese version of the marked copy. Excuse me, let me go back to it. That is page 123 of the marked copy in the Chinese version. That is section 17. That is, people cannot practice dentistry in a premises that is unsuitable for the practice of dentistry. So, regardless of what is stated in Schedule 2 for dentists and dental care professionals alike, they would be subject to Section 17. And if they do not fulfill such conditions, they will be subject to inquiries. And the conditions stated in the schedule would be additional conditions. So, for example, with a dentist being present or supervised by a dentist, these are additional conditions. That's why we're specifying them in column 4. Thank you. Please proceed. Now, for dental therapists, again, A, B, C, D would be the same as those for dental hygienists. Starting from E, these would be the more complicated work. For example, for E, the filling of a tooth set out below of another person, that is to say, the carrying out of cavity preparation and the subsequent insertion of any lining, base, dressing, or permanent filling, a decayed tooth, or a tooth with a dental anomaly. And the conditions set out in sections 1, 2, and 3 of part 2 of this schedule. So one can only perform such on a child under 18 unless they have undertaken training or they have been authorized by the Secretary of Health to be qualified to provide such services. So dental therapists will mainly provide such services to children aged under 18. F, the carrying out of an indirect pulp capping on a tooth of another person. G, the direct restoration of an incisor of another person that is fractured due to a trauma. With restoration, it is meant that if there is a broken tooth, it can be restored with non-invasive means. That's why it can be performed by a dental therapist. H, the carrying out of primary tooth pulpotomy on another person. So this can be done on someone aged 18 or above. That's why we do not have the condition set out in section 3 included here. I, the extraction of a tooth set out below of another person using dental forceps. That is to say, this extraction of a tooth without incision. So for a primary tooth, a decayed tooth, or a mobile permanent tooth, these, unlike wisdom teeth, would not require incising of the jaw to extract such teeth, we would consider such work to be less harsh, which is why we would allow dental therapists to do that. J, the extraction of an erupted permanent tooth of another person using dental forceps. And this is again what the dental therapists are doing at the moment, which is why we have allowed dental therapists to continue performing such work upon the passage of the bill. Ms. Chen Ho-yan, I want to ask, so for some children, they have some ulcers in their teeth. I see that you did not include such condition in the schedule. Is it the case that you will not allow for exceptions in these? Would you allow, for example, others to be stated as a category? Say for tooth abscess, it can be relatively minor. Should we allow the flexibility of having dental therapists deal with the less serious cases of tooth abscess? Let me talk about the schedule, and then I'll let the Department of Health colleague answer the question about tooth abscess. As said before, for page 164 of the markup copy in the Chinese version, that is, Secretary for Health can, by publishing in the Gazette, amend this schedule. So if necessary, we can expand the scope of work of dental therapists in future. As for tooth abscess, I'll let Dr. Cho answer the question. Thank you. Thank you, member, for the question. For tooth abscess, it would depend on whether it is a primary tooth or a permanent tooth. That is, if it is a primary tooth, it would relate to H, that is the carrying out of primary tooth pulpotomy. That is, we would remove the pulp as well as some blood capillaries involved. If it can be cleared out, the tooth abscess can be healed. If it goes beyond this, that is, the pulpotomy cannot successfully eliminate tooth abscess, the treatment would get more complicated from there. And in the Department of Health, it would require a dental officer to perform the treatment beyond that stage. Well, I think her question is actually answered by the information of a schedule. It's just that they did not specify the condition tooth abscess in the schedule. Thank you. Thank you. Now, part 2, conditions. Let's first look at section 1. Before the service is provided by the registered dental care professional concerned to another person, a registered dentist or a person with professional registration has assessed the medical history of and examined the patient and has, based on the assessment and examination, prescribed that the service is to be provided to the patient. So basically, prior screening by a dentist would be required. Section 2, the service is provided on any premises by the registered dental care professional concerned in accordance with the directions of a registered dentist or a person with professional registration who is present on the premises at all times when the service is provided. Section 3, either A, the patient is under the age of 18 years, or B, if the patient has attained the age of 18 years, the registered dental care professional concerned has completed a training program recognized by the Council for the purposes of this section, as mentioned earlier, or 2, a consultant dental surgeon appointed by the Director of Health for this purpose has certified that the individual is capable of providing the service on the ground that the registered dental care dental care professional has acquired the relevant knowledge and experience and is competent to provide such services. Thank you. Please proceed. Part 3, qualifications. Section 1, persons specified for the class of dental hygienist. There are 4 categories at the moment. 2 So A, a person who holds a higher diploma in dental hygiene awarded by the Prince Philip Dental Hospital and the School of Professional and Continuing Education of the University of Hong Kong. And B, a person who has completed a training program in dental hygiene that is recognized by the Council for registration as a registered dental care professional. So the difference with A and B would mainly be the fact that one would be local qualification, the other would be a non-local qualification. There are 2 other categories, so in total there would be 4. For C, a person who has completed a training program in dental hygiene solely or jointly organized by the Department of Health that is recognized by the Director of Health for registration as a registered dental care professional. Or D, this would be a grandfather clause or a transitional profession, essentially. A person whose name is recorded immediately before the commencement date of this paragraph on a roll maintained under Regulation 4(2) of the Ancillary Dental Workers, Dental Hygienists regulations as enforced immediately before that date. Alright, please proceed. Section 2, persons specified for a class of dental therapists. We would have to assess qualifications of dental therapists in future. For hygienists, we have therefore repealed A of Section 1 for dental hygienists because it would be an overlap with our proposed section. For persons specified for a class of dental therapists, we have similar requirements for A and B and C. For D, it is a bit different. That is, a person who has at any time served in the grade of dental therapist in the government other than a person who has only served at the rank of student dental therapist. We have specified this because before there are several ranks for dental therapists, and there are some student dental therapists. If they have yet to graduate, they would only be student dental therapists. So we want to make sure only graduates can be dental therapists in future. Thank you. Dr. David Lam. I want to ask about 1B and specifically 1B for dental hygienists. They have completed a training program recognized by the council and they can register as a dental hygienist. It's the same for dental therapists. So it would be the council assessing the training qualification. If the council has any doubts, can they administer an examination for the individual? Thank you. At the moment, there is no licensing examination. It would only rely on the council assessing whether the course is recognized. In future, the council will be allowed to assess qualifications in relation to dental care professionals. So they can assess overseas qualifications in future to see if such qualifications should be recognized. So an examination would not be administered. Correct. Right now, for dental hygienists and dental therapists, at the moment, they are not administered any licensing examination. Professor Chen Wing-Kwong, thank you. I have a concern. Right now, the Dental Council cannot assess fully, for example, the practicum arrangements. So it circles back to the question. If the Dental Council cannot have effective supervision of dentistry program students for practicum hours, Has that issue been resolved? Is there now effective supervision? We should have stringent requirements for practicum hours. We don't want to make the same mistake again. Thank you. Mr. Ching, thank you. It is as the members said. We do see such requirement. That's why if you look at 39 of the marked up copy in the Chinese version of Section 5C, that is the functions of an education accreditation committee, would have to assess the quality and the structure of training to be provided. So basically, we are strengthening supervision through the Education and Accreditation Committee. Thank you. Well, we can administer an examination even if we do not have effective supervision from the school. That would act as an option to identify the performance. And I would say this, if the students do not pass the relevant assessments, if they fail, they wouldn't pass either. So that would be a safeguard too. Thank you. Well, let me say this again for dental therapists. Like dental hygienists, Section 2A will be repealed because it would overlap with the proposed section. Thank you. Please proceed. For Schedule 4 will be on institutions. As I said earlier, this schedule can be amended if necessary in future by a Gazetted notice. Right now, there are 4 institutions included here. For Schedule 5 institutions, these are the same 4 institutions in Schedule 4. Please proceed. Schedule 6 institutions for internship. Right now, there are only 2 institutions, the Department of Health and the Hospital Authority. And Schedule 7 is the same for period of assessment. For Schedule 8 specified period, that is internship, would be 12 months, and the period of assessment would also be 12 months. And the Dental Council may consider shortening the period of assessment if necessary, or extending the period of assessment. Alright, please proceed. Schedule 9. Provisions with respect to committee established under Section 5AC and subcommittee established under Section 5AD. Let's first talk about the interpretation. Committee means a committee established under Section 5AC, and subcommittee means a subcommittee established under Section 5AD. The second section would be the terms of members, and the members would refer to committee members. Subsection 1 subject to subsection 3 and section 3 of this schedule. A member of a committee other than one established under Section 5AC2 holds office for the period specified in the member's letter of appointment and is eligible for reappointment. Why is it other than one established under Section 5AC2? If you look at the specific provision, 5AC would refer to Education Accreditation Committee, Health Committee, Preliminary Investigation Committee, and the 2 other committees. And these 5 committees have been clearly defined in previous sections. That's why we will not say specifically what the other committees are. Alright, let's move on. Subsection 2, subject to subsection 3 and section 3 of this schedule, a member of a subcommittee holds office for the period specified in the member's letter for appointment and is eligible for reappointment. And a member of a committee or subcommittee may at any time resign by giving written notice. There are no questions. Please proceed. Section 3, vacation of office. If an order is made under Section 18 or 18A in respect of a member of a committee or subcommittee, the member ceases to be such a member. And this is in line with what is done for members of other committees and subcommittees.
暫時成員呢，就係
Next, temporary members. If a member of a committee is temporarily unable to perform the functions as a member of the committee during a period, another person eligible for appointment as such a member may be appointed by the chairperson to be temporarily a member of the committee during the period. In brackets 2 is similar. If a member of a subcommittee established by a committee is temporarily unable to perform the functions as a member of the subcommittee during a period, another person who is eligible for appointment as such a member may be appointed by the chairperson or the chairperson of the committee to be temporarily a member of the subcommittee during the period. No question? Let's continue. Section 5, outgoing member to continue transacting business. If a committee or subcommittee member is considering a complaint or information or conducting a hearing or review at a time when a notice of registration is given by a person under Section 2, bracket 3 to the schedule, or B, the membership or temporary membership of the committee or subcommittee of a person terminates otherwise than by resignation. These are to make arrangements for how these outgoing members to continue transacting business. The person must, for a person that is a member of a committee, if requested by the council or the chairperson, continue to be a member of the committee for the purpose of completing the performance of the person's function in respect of that complaint, information, hearing, or review, and for no other purpose. Or B, for a person that is a member of the subcommittee, if requested by the council, the chairperson, the committee that established the subcommittee, or the chairperson of the committee continue to be a member of the subcommittee for the purpose of completing the performance of the person's function in respect of that complaint, information, hearing, or review, and for no other purpose. And that is for the sole purpose of completing the hearing in order to ensure continuity for the case. Mr. Dennis Lam. Thank you, Chairman. If these members are to stay until they finish their duties, will there be any temporary members? Mr. Ronald Chang. If someone is not requested by the Dental Council of Hong Kong, then he or she will not perform such a function unless so requested by the Dental Council of Hong Kong. Section 6, meetings. Meetings. At a meeting of a committee or subcommittee, except for a committee established under Section 5AC, brackets 2E, the chairperson of the committee or subcommittee must preside at the meeting. And B, except for a committee established under Section 5AC, brackets 2, if the chairperson is absent, the members present must elect one of them to preside at a meeting. Subsection 2, a question for determination at any meeting of a committee or subcommittee must be decided by a majority of the members present in voting on the question. Subsection 3, at any meeting of a committee or subcommittee, the chairperson of the committee or subcommittee has an original vote, and if on any question the votes are equally divided, a casting vote. We will consider subsections 4 to 7 altogether in order to ensure consistency. Mr. Dennis Lam. Thank you, Chairman. We just now talked about temporary members. If a member of a committee or subcommittee resigns, temporary members of committee or subcommittees will be appointed. So, are these temporary members of committee or subcommittee, or will they become full members of committee or subcommittees? What are their powers? Are their powers actually the same as full members of committee and subcommittees? There's no clear provision. Thank you. Regarding temporary members of committee and subcommittee, it is said that someone cannot perform the function for a short period of time temporarily, so that is not a resignation. If someone resigns, are the powers the same as full committee or subcommittee members? Yes, that is the case. That is actually provided under Cap 1 of the laws of Hong Kong. Subsection 7, Secretary. 1. The Council may appoint a person to be a secretary to a committee. Subsection 2. A committee establishing a subcommittee may appoint a person to be a secretary to the subcommittee. Section 8. Procedure. Except where express provision about the procedure of a committee or subcommittee is made in this ordinance or regulations made under Section 29, a committee or subcommittee may regulate its own procedure. Schedule 10. Conditions for full registration. This should be made reference to Section 7C, 8, and 29C. And that is about the licensing examination for dentists with special or limited registration. How they migrate to full registration, this schedule provides the relevant procedures. For a person who has worked under full-time employment as a person with special registration in one or more Schedule 5 institutions at any time during the period mentioned in Section 8(1)(c)(1), the person has passed or been exempted under Section 7C from the clinical part of the licensing examination. These two subsections provide conditions for full registration. Subsection 1 specifies for a person who has not worked under full-time employment, whereas subsection 2 specifies for a person who has worked under full-time employment. Please continue. In Schedule 1, Part 1 matters relating to registration, Section 1 interpretation of Part 1 of Schedule 11. In this part, amended ordinance means this ordinance is amended by the amendment ordinance. Existing register means the general register kept under Section 7(1) of the pre-amended ordinance. Existing prescribed fee in relation to a matter means the fee prescribed for the matter in the pre-amended regulation. And there are pre-amended ordinance and pre-amended regulation. Existing registrant means a person whose name is contained in the existing register immediately before the commencement date. New register means the general register kept under Section 7(1) of the amended ordinance. Amended ordinance means this ordinance as amended by the amendment ordinance. For the purpose of this part, a person is on the resident list of the existing register if the name of the person is contained in a form prepared in accordance with Regulation 3A of the pre-amended regulation, and B, a person is on the non-resident list of the existing register if the name of the person is contained in a form prepared in accordance with Regulation 3B of the pre-amended regulation. Resident list and non-resident list, we want to cover these under this section or subsection. We will use these two definitions in the subsequent provisions. No question, please continue. Section 2, registration and register. On the amendment date, an existing registrant is to be regarded as a person with full registration. That is, for dentists on general register, they will become full registration dentists. So these dentists need not worry about their loss of eligibility for migration to full registration. Section 2, Registration and Register. Subsection 2. Accordingly, the registrar must, on the commencement day, A. Transfer the name and particulars of each existing registrant on the resident list of the existing register to the practicing list of Part 1 of the new register. B. Transfer the name and particulars of each existing registrant on the non-resident list on the existing register to the non-practicing list of Part 1 of the new register. Subsection 3. On the transfer of a person's name and particulars under subsection 2b, the person is to be regarded as having been issued a retention certificate under section 12I(3) of the amended ordinance that is subject to section 12I(6) of the amended ordinance to be enforced until A. If the commencement date falls on a date not later than the 30th of June of a year, the end of that year, or B. If the commencement date falls on a date later than the 30th of June of a year, that is the end of the following year. For the ordinance taking effect before the 30th of June, that will run until the end of October. Otherwise, that will end in the next legislative year. That is for the regulation on the retention certificate. Dr. David Lam. Thank you, Chairman. I'd like to ask about 3A and 3B. 3A the grace period less than 1 year, whereas for 3B over 1 year. I'd like to know the difference between that. For the 30th of June, the validity period will run until the 30th of June next year. For transitional provisions, we have drawn reference from the relevant provisions. So there's a cutoff point, as we call it in English. We need to set a date. I agree this will be clearer to dentists. Section 3 addresses. This section applies to a person whose name and particulars are transferred to the new register under Section 2(2) of this schedule. In subsection 2, if the name and particulars of the person are transferred under section 2(2)(a) of this schedule, A. If only one address is transferred, that address is to be regarded as an address provided on the commencement date by the person under section 12G(1) and (2) of the amended ordinance. We will regard it as the latest address or the last known address. If more than one address is so transferred, these cases are very common right now. Brackets 1. All those addresses are to be regarded as addresses provided on the commencement date by the person under section 12G(2) of the amended ordinance. But which one will be regarded as the usual address? We need to take a look at brackets 2. The latest address indicated by the person to the registrar before the commencement date as the corresponding address is to be regarded as an address provided on the commencement date by the person under section 12G(1) of the amended ordinance. Subsection 3. If the name and particulars of the person are transferred under section 2(2)(b) of the schedule, the address in Hong Kong so transfer is to be regarded as an address provided on the commencement date by the person under section 12G(1) of the amended ordinance. Please continue. Section 4. Existing certification of registration. On and after the commencement date, a certificate of registration issued under Section 10, Brackets 1 of the pre-amended ordinance that was enforced immediately before the commencement date continues to be enforced as if it were issued under Section 10 of the amended ordinance to a person with full registration. Accordingly, a duplicate or certified copy of such a certificate is to be regarded as a duplicate or certified copy of a certificate of registration issued under Section 10 of the amended ordinance to a person with full registration. Paragraph B. Pending application for registration. An application made under Section 9 of the pre-amended ordinance that was pending immediately before the commencement date is subject to subsection brackets 2 to continue to be processed under that section. However, in subparagraph 2, if an application referred to in subsection 1 is approved on or after the commencement date, the registrar must, after the existing prescribed fee has been paid, A. Enter the applicant's name in 1. If the applicant indicated that the applicant wished, if the application was approved, to have the applicant's name contained in the resident list of the existing register, the practicing list of Part 1 of the new register, or 2. If the applicant indicated that the applicant wished, or if the application was approved, to have the applicant's name contained in the non-resident list of the existing register, the non-practicing list of Part 1 of the new register, and be issued to the applicant's certificate of registration under Section 10 of the amended ordinance. No question. Let's continue. Paragraph 6. Restoration of name to register on application. Subparagraph 1. This section applies if A. Before the commencement date, a person's name was removed from the existing register, and B. The person has, before the commencement date, applied to the council for the registration of the person's name to the existing register under Section 22, Bracket 3 of the pre-amended ordinance, and C. The application was pending immediately before the commencement date. Subparagraph 2. The application is subject to subsection 3 to continue to be processed under Section 22, Bracket 3 of the pre-amended ordinance. In subparagraph 3, if the application is allowed on or after the commencement date, the registrar must, after the existing prescribed fee has been paid, enter the applicant's name in A. If the applicant indicated that the applicant wished, if the application was allowed to have the applicant's name contained in the resident list of the existing register, the practicing list of Part 1 of the new register. In subparagraph 4, on entering the person's name in the non-practicing list of Part 1 of the new register under this new section, the person is to be regarded as having been issued a retention certificate under Section 12I, Bracket 3 of the amended ordinance that is subject to Section 12I, Bracket 6 of the amended ordinance to be enforced. Subparagraph 5. On entering the person's name under this section, the certificate of registration issued to the person under Section 10, Bracket 1 of the pre-amended ordinance that was enforced immediately before the removal is to be regarded as being enforced as if it were issued under Section 10 of the amended ordinance to a person with full registration. No question. Let's continue. Paragraph 7. Existing practicing certificate. On and after the commencement date, a practicing certificate issued to a person under Section 12A, Bracket 2 of the pre-amended ordinance that was enforced immediately before the commencement date continues to be enforced for the unexpired period as if it were a practicing certificate issued under Section 12A, Bracket 2 of the amended ordinance to A. If the person is a person mentioned in Section 11A, Bracket A1 of the pre-amended ordinance, a person with full registration, or brackets B, if the person is a person mentioned in Section 11A, brackets 8B of the pre-amended ordinance, a person with limited registration. So the practicing certificate will be one with full registration. If the person is a person mentioned in Section 11A, brackets 8B of the pre-amended ordinance, a person with limited registration. No question, please continue. 8. Pending application for practicing certificate. An application made by a person under Section 11A on the pre-amended ordinance that was pending immediately before the commencement date is subject to subsection 2 to continue to be processed under that section. Subparagraph 2. If an application referred to in subsection brackets 1 is approved on or after the commencement date, the Council must, after the existing prescribed fee has been paid, issue a practicing certificate under Section 11A of the amended ordinance to the person as if the application were made by A. If the person is a person mentioned in Section 12A, 11A brackets 8A of the pre-amended ordinance, a person with full registration.
Part 2. Matters relating to council and committees. The provisions will be implemented in phases. That is why we have to distinguish between pre-amended council and committees and amended council and committees. Under interpretation, amended ordinance means this ordinance as amended by the amendment ordinance. Former council means the council established under Section 4 of the pre-amended ordinance. Former EAC means the Education and Accreditation Committee established under Section 5B of the pre-amended ordinance. Former PIC means the PIC established under Regulation 12 of the pre-amended regulation. Amended ordinance and amendment ordinance are the same as set out previously. Section 10, former council members. This section applies if before the commencement date a person was appointed as a member of the former council described in Section 4A to BA, C, D, or E of the pre-amended ordinance. That is, if they are not staff members of the Department of Health, then this section applies. And immediately before the commencement date, the term of office of the member is not yet expired. In Section 4 of the pre-amended ordinance, it said that the terms of office is 3 years, but unless otherwise specified, this group of people would be deemed to have their term of office have expired, so that when we have a new ordinance, we can elect for new members. 11, Secretary of and Legal Advisor to Council. Under Section 4(6), on and after the amendment date, the person appointed under that of the pre-amended ordinance as the Secretary of the former Council was holding office immediately before and that day continues to hold office. 2, on or after the commencement date, the performance or the person as the legal advisor to the former Council would continue to hold office. No question, please continue. Section 12, former members of Education Accreditation Committee. This section applies if, before the commencement date, a person was appointed as a member of the former EAC and immediately before the commencement date, the term of office of the member has not yet expired. Although the original ordinance said that the terms of office are 3 years, when we have the new ordinance, the term of office of the members would expire. Section 13, former members of the PIC, the same applies. In the pre-amended ordinance, the terms of office is said to be 3 years, and after the ordinance is amended, we will have new members to the PIC. Thank you. Dr. David Lam. For dental council or the members of the committee, when the inquiries have not been completed, and if the chairman thinks that the members of the PIC should remain to scrutinize the case, should those members remain? Thank you. We will detail that in Section 14. Section 14, complaint or information submitted to a former PIC. As mentioned by Dr. David Lam, there are some cases that are outstanding when the bill is passed. Should we ask the old members to continue to handle the case, or should we appoint new members to handle the case? Under Section 14(1), this section applies if, before the commencement date, either the Secretary has submitted a complaint or an information to the former PIC under Regulation 13 of the pre-amended regulation, or a complaint or an information has been referred back to the former PIC under Regulation 19(1) of the pre-amended regulation. B, the complaint or information has not been disposed of by the former PIC. So how should we handle it when this happens? We can refer to bracket 2. For the purpose of subsection 1B, a complaint or an information has been disposed of by the former PIC if A, the chairman of the former PIC we're talking about page 184, has directed under Regulation 15(1) of the pre-amended regulation that the complaint or information should not be proceeded further on the ground that it is frivolous and groundless, or the former PIC has determined under Regulation 15(a)(2) of the pre-amended regulation as to whether the complaint or information is to be referred to the Council for inquiry. So before and after the commencement date of the ordinance, Regulations 14, 15, 15A, and so on and so forth of the pre-amended regulation continue to apply. So when the case have not been dealt with, we will make use of or invoke the pre-amended regulation. To the extent that it relates to the consideration of the complaint or information, Regulation 12 of the pre-amended regulation continues to apply. So we will make use of the pre-amended regulations and old PIC members to handle those cases. Bracket 4. If the former PIC makes a determination under Regulation 15(2)(b) of the pre-amended regulation to refer the complaint or information to the Council, the determination is to be regarded as being made by the PIC. Follow-up questions? Dr. Lam? This is about PIC. What about the disciplinary hearing of the Dental Council? Well, that's Section 15. My apologies. Should we go back to Section 13? Any questions? Now we move on to 15. Under the Council also handles certain cases in 15(1). This section applies if before the commencement date, the former PIC determined under Regulation 15(a)(2)(b) of the pre-amended regulation to refer a case against a person to former Council for inquiry to be held. The Secretary has read the notice of inquiry at the opening of an inquiry held for the case. So why do we stress that the notice of inquiry should have been read? When the Dental Council starts the case on the person, that the starting time will be the time when the notice is read. That is why we use that as the basis. What if the case have not been disposed of? We will invoke such a section. Under bracket 2, we will set out under what circumstances the conditions will no longer be able to apply. For example, A, the former Council has announced that the person is charged is not guilty, and if the former Council has announced that the person is guilty, and a sentence has been announced under the regulation of the pre-amended regulation. 3, on or and after the commencement date, Section 18, 19, 20, and 21 of the pre-amended ordinance and Regulation 23 of Part 4 of the pre-amended regulation continue to apply in relation to the hearing of the inquiry. B, to the extent that it relates to the hearing of the inquiry, Section 4 of the pre-amended ordinance continues to apply. So for old cases, we will invoke pre-amended ordinance and regulations and former PIC members to handle those cases. 16, complaint or information referred back to former PIC. Under certain circumstances, a Dental Council can refer some cases to former PIC, and this section details the arrangement. This section applies before the commencement date. A complaint or an information has been referred by the former PIC to the former Council under Regulation 17(1) of the pre-amended regulation, or on or after the commencement date, a complaint or an information is referred by the former PIC to the Council under Regulation 17(1) of the pre-amended regulation because of the operation of Section 14 of this schedule. Bracket 2, on and after the commencement date, the Council may continue to exercise the power to refer the complaint or information back to the former PIC under Regulation 19(1) of the pre-amended regulation. Bracket 3, if the Council refers a complaint or an information back to the former PIC under subsection 2, Section 14 of this schedule applies in relation to the complaint or information as if it were a complaint or information referred back to the former PIC under Regulation 19(1) of the pre-amended regulation before the commencement date. To put it simply, for old cases, they will be dealt with the old ways. Any questions? If there being no questions, that's the end of our clause-by-clause examination. Any other business? The next meeting will be held on the 24th of May, Friday, 8:30 a.m. to 10:30 a.m. The next meeting will be from 10:45 to 12:45. There being no other business, the meeting is adjourned. Thank you.